the fact, even though the loopholes are closing and we're very keen to continue to do that, there are still quite significant loopholes and abuse is still happening. We are still seeing criminal cases involving teachers whom we convicted in the last couple of years for recent abuse and non-recent abuse as well. It is complacent to say just because we haven't had allegation against our school in the last 5 or 10 years, therefore it's not happening. Cases in England and Wales, you have technically until your 21st birthday to register your case at court. That's because you were abused as a child. Instead of having the usual statutory 3-year limit, you have 3 years from age of majority, so age of 18. So if you suffered abuse as a child, 21st birthday, unless there's capacity issues. Now, most of our clients are in their 40s plus, like I mentioned. So what we need to rely upon is Section 33 of the Limitation Act, 1980. And in principle, it has 2 criteria. One, to show a fair trial is still possible, even though it's out of time. So are we able to prove the abuse? Are we able to prove the institution should be held responsible? Are we able to prove this is an impact on you and the level and extent of that impact? And the second criteria, which I've always disagreed with because I think it is victim blaming, why did you not come forward earlier? Now, if the first criteria has been satisfied, a fair trial is possible, the second criteria, in my personal view, shouldn't be in play because it's victim blaming, but we have to justify it. So why did you not come forward earlier? Elements of blame, embarrassment, shame, fear of people in authority. We have to go through those criteria and we have to justify it. It becomes harder when you've told your partner when you're 25 and you're spoken to a therapist when you're 35. You haven't started legal case until you're 45. You have to justify those different sections of your life. Obviously, telling your partner is very different to telling some random lawyer. I get that. Seeking medical help and support from a therapist is very different to, again, pursuing a legal action through the police and or a civil lawyer. I appreciate the differences, but we do need to justify those steps. And I think that one thing which we are campaigning for and continue to campaign for is that second element should be removed because it's inherently difficult for abuse survivors to talk about abuse. So we shouldn't need to prove that. But that's the current rules in the country of England and Wales. The vast majority of our clients, 98%, 99% are all over the age of 21. So it's the norm, to be frank, that happens. And we are successful for our clients. So it's an issue which we see every single day. We're fully aware of. But again, 2 to 3% under 21. Some of them are in their 20s, but they're still out of time. Even if you're a day over 21, you're out of time technically.
Yeah, it seems crazy to me, just as someone who works with people who've experienced abuse and trauma, to put that limitation in place there. But what I'm hearing from you is that, if someone to Google these things, they might be put off instantly and go, well, I'm 50, I'm not 21, so what's the point? But what you're saying is, all it means is that the legal team has to do some work on some of those other elements. Such as why didn't you come forward up till now and substantiate that, and what was the other one? Sorry, is to substantiate why you came forward.
And to show that a fair trial is possible. Same as you think, what's the point? My abuse is dead. Same point in that we have been able to bring civil action successfully on a number of occasions against dead abusers, or where perhaps there was insufficient evidence. We pursue a civil case and sometimes actually results in a criminal case because the police haven't been able to, for some reason, to reach out to survivors and the like. It is possible, it is doable. Remember, Jimmy Savile, as an example, was never charged or convicted of abuse, but it was found in the civil that he was, on balance probabilities, an abuser. So I think, again, the key thing is speaking, even if the civil lawyers say they cannot assist, the signposting is important. So whether it's to therapists, MPs, inquiries, wherever it is, it goes back to that initial point. What do you want to achieve from doing this? What elements of closure and justice do you want? And how do you achieve it?